Well, let me be more pointed with you about it then. Professor Jones makes the appropriate point that Congress authorizes. This is not a situation like, for instance, in Korea, where President Truman acted completely without congressional authorization, underscoring again, I think, Charlie's point last night that this is not a red state, blue state, Democrat, Republican phenomenon. Congress did pass overwhelmingly the authorization for the use of military force. It is an extremely broadly written authorization. It has never been withdrawn. Is it your position that that authorizes that which follows, and that certainly everything, put this to the whole panel, certainly everything which has gone on in the detention and interrogation realm has received the prior sanction of the legislative branch through the authorization?
So what's the question?
The question is, there's nothing to worry about. The President is not acting beyond the reach of that which Congress has authorized him to do, and the President's doing everything fine because Congress, we have had checks and balances, and if the Congress wants to take away the authorization, it can. It knows how to do it. It did it in Vietnam. It can withdraw the authorization.
I think that underscores the point that I'm making about the role of the law and the role of Congress. If we look at what Congress has done, you brought up the MCA. If we look at the MCA and what it attempted to do, it attempts to criminalize and give the commissions jurisdiction over people who've provided material support to terrorism. Okay. Well, what that really means is that now there is no law of war that says material support was criminalized. What we have been operating under, parameters that allow for prosecution and attacks on people who were participating in hostilities. Okay, what that means is that people who were already detained, okay, are now possibly guilty of laws that were not even on the books at the time that they committed the acts. So, again, this is just an exercise in, I would say, strategic legalism, and I think that this is an instance where the Congress now did not act initially, but in response to the judicial decision, they now are acting in the later phase after the conduct has taken place.
Ambassador, let me ask you: did you get the sense within the administration at this really critical period, and I think it was clear to us at least, that the decision in Rasul, the decisions in Hamdi in 2004 took the administration by surprise. Do you have a sense, or did they, within the administration, have the sense that the rug was pulled out from under you, that you guys thought that you had the authorization that you needed and the support that you needed from Congress to do that which you were doing, and then suddenly the ground shifted and it was unfair to the effort that you had made?
Well, I'm not sure it was, unfair because, a few things happened along the way. We were able to begin to read the tea leaves as to which way some of the decisions were going based on the arguments. But I think the administration did early on believe that this was fully within the authority of the executive branch, and I think again partially because of the interpretation of the law, partially because we did fully brief Congress, and partially because we went on and were doing what we were doing for several years before people began to raise questions. So then once it actually did get into the courts, it opened up a whole line of complexities and issues that people needed to examine more closely and probably could have or should have earlier.
On the other hand, it's true that the authorization doesn't say anything about detention, and it doesn't say anything about treatment of prisoners. How we fix your time, by the way? All right. Let's just make this the last question, and let's open it up some. I want to get the audience. It doesn't say anything about treatment of prisoners. It doesn't say anything about detention. Do you think that the authorization by itself could have been, and the President's declaration that the conventions don't apply except to the extent that we choose to do it, provides adequate protection for and replacement of the existing legal structure, the pre-existing legal structure that Professor Graham talked about last night?
I'll start that one. I have no doubt that whether there is or isn't an AUMF, the executive has the authority to do what countries are entitled to do under conventional and customary laws of war. And what that is to detain people as either prisoners of war or civilians in situations of state-to-state armed conflict, wars between country A and country B. The entire fabric of the international humanitarian law of international armed conflict is built around the concepts of who can be targeted, who can be detained, and what their status is upon detention. But when you get into a question of armed conflict between a state and a non-state entity, a rebel group or a transnational terrorist organization, then the presumption of the laws of war is that domestic law will govern the question of detention, the power to detain and the right to challenge detention. So the conclusion that I think is inevitable from that is that as long as the United States was at war against Afghanistan, then it had an obligation to classify detainees as either POWs under the Third Geneva Convention or civilians under the Fourth Geneva Convention, and it had a right to detain people under the rubric of those conventions. Once, say, the Taliban control of Afghanistan ended and the international phase of the conflict ended, then the question of legal frameworks for detention become more complicated. Is it U.S. law? Is it Afghani law? There, questions concerning the application of the AUMF and whether or not it entitles the U.S. to detain individuals are more pertinent. And I think the conclusion that should have been drawn is that if Congress is going to pass a resolution for conduct of armed conflict, then it needed to do a better job of attending to precisely those simple fundamental issues that are the incidents of armed conflict, that is targeting, that is detention, that is treatment, and that is trials. And Congress failed to do so. If Congress fails to do so, then I think it's completely appropriate for the courts to step in those situations, as it did do so on the question of, for example, the power to detain. It said habeas corpus applied. Congress also stepped in with the Military Commission Act on questions of trials and other issues. But once again, it made some substantial mistakes.